Welcome to Module 4. In Module 3, you learned that managers and employees have a shared obligation to prevent sexual harassment in the workplace. However, unlike non-supervisory employees, managers have an additional responsibility to protect employees from retaliation if and when sexual harassment complaints occur in the workplace. In Module 4, Guarding Against Retaliation, you will learn the important role managers play in guarding against retaliation. Retaliation includes any adverse action taken against an employee for filing a complaint or supporting or bearing witness to another employee's complaint. The most common type of retaliation claim involves an employee who alleges that he or she was first harassed or subjected to discrimination because of his or her membership in a protected class, and later punished for making a complaint to the employer or a relevant federal agency. Fulton County policy as well as federal law strictly prohibit retaliating against anyone who has brought a claim of discrimination or sexual harassment, or who has participated in an investigation. Retaliation is considered a separate offense, whether or not there has been a cause finding in the original sexual harassment claim. Such offenses will be investigated and disciplined in accordance with the Fulton County personnel policies previously discussed. To make a basic case for retaliation, an employee has to show the following three things. The employee engaged in protected activity, such as filing a complaint. The employer subjected the employee to an adverse action, such as discipline or harassment, after filing the complaint. And the evidence shows a causal connection between the adverse employment action and complaint activity. While the definition of what constitutes retaliation is straightforward, understanding the wide-ranging protections associated with retaliation coverage is more complex. There are three main terms that are used to describe retaliation and its associated protections. Retaliation occurs when an employer, employment agency, or labor organization takes an adverse action against a covered individual because he or she engaged in a protected activity. An adverse action is an action taken to try to keep someone from opposing a discriminatory practice or from participating in an employment discrimination proceeding. Examples of adverse actions include employment actions such as termination, refusal to hire, denial of promotion, other actions affecting employment such as threats, unjustified negative evaluations, unjustified negative references, increased surveillance, and any other actions such as an assault or unfounded civil or criminal charges that are likely to deter reasonable people from pursuing their rights. Covered individuals are people who have opposed unlawful practices, participated in proceedings, or requested accommodations related to employment discrimination based on race, color, sex, religion, national origin, age, genetic information, or disability. Individuals who have a close association with someone who has engaged in such protected activity also are covered individuals. For example, it is illegal to terminate an employee because his spouse participated in employment discrimination litigation or DCRC complaint filings. However, individuals who have brought attention to violations of law other than employment discrimination are not covered individuals for purposes of anti-discrimination retaliation laws. For example, whistleblowers who raise ethical, financial, or other concerns unrelated to employment discrimination are not protected by Fulton County's Equal Employment Opportunity and Prejudicial Acts Policy 103-16 or Equal Employment Opportunity Enforced Employment Discrimination Laws. Protected activity includes opposition to a practice believed to be unlawful discrimination. Opposition is informing an employer that you believe that he or she is engaging in prohibited discrimination. Opposition is protected from retaliation as long as it is based on a reasonable, good faith belief that the complained of practice violates anti-discrimination law and the manner of the opposition is reasonable. Examples of protected activity include participation in equal employment opportunity activities, assisting with complaint filing, providing physical or testimonial evidence in discrimination investigations, complaining to anyone about alleged discrimination against oneself or others, threatening to file a charge of discrimination, picketing in opposition to discrimination, or refusing to obey an order reasonably believed to be discriminatory. Examples of activities that are not protected opposition include employee actions not related to employment discrimination or protected activity engagement that interfere with job performance so as to render the employee ineffective, or unlawful activities such as acts or threats of violence. A manager must lead by example and always remember, retaliation includes any adverse action taken against an employee for filing a complaint or supporting or bearing witness to another employee's complaint. Individuals who have brought attention to violations of law other than employment discrimination are not covered individuals for purposes of anti-discrimination retaliation laws and Fulton County's Equal Employment Opportunity and Prejudicial Acts Policy 103-16. Actions that interfere with job performance so as to render the employee ineffective, or unlawful activities such as acts or threats of violence are not covered under anti-discrimination retaliation laws. Retaliation for engaging in protected activity can occur at any time, regardless of the length of time from the protected activity. However, an individual only has 30 business days from the date of retaliation to file a charge with the Office of Diversity and Civil Rights Compliance, and 180 days to file a charge with the EEOC. Now, let's put your knowledge to the test. True or false? Fulton County's Equal Employment Opportunity and Prejudicial Acts Policy prohibits retaliation against individuals who file sexual harassment, ethical, and integrity complaints. The correct answer is false. Fulton County's Equal Employment Opportunity and Prejudicial Acts Policy only prohibits retaliation against individuals that file a complaint or supporting or bearing witness to another employee's complaint related to employment discrimination. Individuals who have brought attention to violations of law other than employment discrimination are not covered individuals for purposes of anti-discrimination retaliation laws. How many days does an employee have to file a complaint with the DCRC? Is it A, 30 business days, B, 100 days, or C, 180 days? The correct answer is A. In accordance with Fulton County Anti-Discrimination Policy, individuals have 30 business days from the date of retaliation to file a charge with the DCRC and 180 days to file a charge with the EEOC. The county's anti-discrimination reporting timeframes encourage employees and managers to report and respond to sexually harassing behaviors promptly. However, once complaint activity occurs, managers have an additional responsibility to implement effective measures to prevent retaliation in the workplace. Although the work of Fulton County managers differs greatly across the organization's respective departments, all managers have the responsibility to institute effective measures to guard against and prevent retaliation in the workplace. By ensuring the implementation of effective prevention measures that include but are not limited to ensuring staff are properly trained, acknowledging the receipt of employee complaints, taking complaints seriously, advising all staff that retaliation is strictly prohibited, ensuring violators are disciplined appropriately, and complying with DCRC investigative provisions. Managers can and will effectively guard against retaliation in the workplace. Managers should always remember, coverage for a retaliation claim is open-ended. The time frame for filing retaliation charges is 30 business days for DCRC and 180 calendar days from the last incident of retaliation for EEOC. The claim extends beyond the employment relationship, and managers are responsible for instituting effective prevention measures in the workplace. Now that you are more aware of the county's anti-retaliation provisions and the managerial responsibilities related to guarding against retaliation, let's put your knowledge to the test with Scenario 2, Pam and her coworkers. Pam complained that she was sexually harassed by a coworker. She alleged that the male coworker, Bob, constantly made comments of a sexual nature towards her, and he forcefully attempted to kiss her. Pam reported her concerns to the Office of Diversity and Civil Rights Compliance and her manager. When Pam advised her manager of her complaints, the manager told her that Bob was simply giving Pam a compliment, and Pam should not complain. 2 days later, Pam was terminated because her manager stated that her complaints would create poor morale in the department. True or false? The manager's decision to fire Pam based on her sexual harassment complaint constitutes retaliation. The correct answer is true. When Pam filed a complaint against Bob and advised the manager of her concerns, she engaged in protected activity. Thus, the manager's decision to terminate Pam based on her complaint activity constitutes retaliation. What is the best preventive measure Pam's manager should employ to guard against retaliation? Should the manager A. meet with Pam and tell her to ignore Bob's behavior? B. advise Pam of the county's anti-retaliation policy and warn her against talking to other employees about Bob's behavior? Or C. acknowledge your receipt of Pam's complaint, inform her the complaint will be taken seriously, and assure her that retaliation is strictly prohibited. The correct answer is C. Acknowledge your receipt of Pam's complaint, inform her the complaint will be taken seriously, and assure her that retaliation is strictly prohibited. Fulton County policy strictly prohibits retaliation in the workplace. All managers have a responsibility to take employee complaints regarding sexual harassment seriously and ensure employees are aware that retaliation is strictly prohibited. Thank you for completing Module 4, Guarding Against Retaliation. With the completion of Module 4, you have successfully concluded the DCRC Prevention Begins With You Refresher Sexual Harassment Prevention Training Program.